The final group of interpretive canons are those based on constitutional or policy-based concerns. Those canons may sometimes steer interpretation of statutes or promulgated rules in a different direction than would the previously discussed grammatical or contextual canons. The constitutional avoidance canon, sometimes called the constitutional doubt canon, directs that, if at all possible, courts will interpret statutes to avoid raising a serious constitutional issue. Even if courts have to stretch a statute's plain meaning, courts will do so, not merely to avoid rendering the statute unconstitutional, but also to avoid even raising a constitutional issue. As Justice Ginsburg once explained, quote, "It has long been our practice, however, before striking a federal statute as impermissibly vague, to consider whether the prescription is amenable to a limiting construction. Federal courts must avoid constitutional difficulties by adopting a limiting interpretation if such a construction is fairly possible." Unquote. This canon dovetails neatly with the Supreme Court's general philosophy of avoiding constitutional judgments regarding congressional acts wherever possible. The canon stands with other tools, such as prudent standing, ripeness, and the political question doctrine, as ways for courts to avoid raising or addressing the constitutionality of statutes. The presumption against retroactivity provides that, unless Congress clearly intends otherwise, civil statutes don't apply retroactively. The Constitution's ex post facto clauses prevent Congress and state legislatures from passing retroactive criminal statutes. But there's not an equivalent constitutional prohibition against non-criminal statutes having retroactive effect, and Congress has occasionally enacted such laws. One such example is the Adam Walsh Child Protection and Safety Act, which required persons convicted of certain sex offenses to register with the Department of Corrections, even if the conviction occurred before the act was passed. Failure to register was itself a felony.